Hello and welcome to NewsClick and the Leaflet. Today we are joined by two eminent personalities of India's legal fraternity. We have with us Justice Madan Lokur, the former judge of the Supreme Court of India, and Indira Jaising, senior advocate of the Supreme Court of India and the founder of both the Leaflet and the Lawyers Collective. And we are going to be discussing a wide range of issues regarding recent developments, the Hathras gang rape and murder case, of course, the kind of rumor mongering, the kind of victim blaming that has been happening around it in the aftermath. Also issues around Bhima Koregaon, the Delhi riots, the kind of conspiracy, the climate of conspiracy that is being, the narrative of conspiracy that's being created in the country. So thank you both of us very much for joining us today. So my first question is regarding the Hathras incident. So we've seen more developments over the past few days. On the one hand, we've seen the Chief Minister of Uttar Pradesh, Yogi Adityanath, declare a conspiracy. We'll of course come to that later. But there's also been a long series of events. Senior Advocate Indira Jaising spoke to us last week on some of these issues, on the systemic aspects. So I just want to ask the both of you, in light of recent events, how do you see both the response of the state and the kind of systemic failures at various levels, at the levels of the police, at the level of the medical fraternity, at the level of administration? How do you see it right now?
So may I just make the comment that I have made earlier, that when you say there's a failure by the state, it's very important to deconstruct the word state, because the failure occurs at many levels. And the first level at which it occurs is the police station. The second level at which it occurs is the hospital. The third level at which it occurs is the district administration, which is responsible for ensuring a free and fair investigation. And I really cannot say how far up the ladder of the state the buck stops. But I would really throw open this question, that do we have any concept in this country of command responsibility, where ultimately it is the Ministry of Home Affairs, and beyond the Ministry of Home Affairs, the cabinet system, the entire cabinet, which takes responsibility for what we consider to be a complete failure in the administration of justice. So,
yes, Prashant, as far as I'm concerned about the Hathras incident, the beginning is terrible and the end is also terrible, right? Now, why do I say that the beginning is terrible? It's an admitted position that this girl was brought to the police station, right? And the police refused to register an FIR for whatever reason. Now, there are instructions that have been given by the Ministry of Home Affairs, and it was reiterated, I think, today or yesterday, that if there is a crime against a woman and it's a cognizable offense, then the police must, it's mandatory, they must register an FIR. Right? Now, this girl was brought to the police station. It was obvious, I think it should have been obvious to the police, that she had been bruised, right? And so therefore an FIR should have been registered, but it was not. Okay, so that's where, right in the beginning, things went wrong. So now people are saying all kinds of things that, oh, she was beaten up by her family and so on and so forth. Fine, assuming it to be so. Even then it has to be registered, right? In a domestic violence, for example, the husband beats the wife. You can't say, oh, because the husband has beaten the wife, therefore I'm not going to register a FIR. It still has to be registered. So the beginning is terrible. The end is terrible. Suddenly in the middle of the night, they go and cremate her. I don't even know whether it's cremation or whether it's just burning the body, because apparently no rituals were carried out, nothing was done. They threw petrol, whatever, and so therefore the whole thing, the beginning is suspicious or terrible, the end is suspicious or terrible. Okay, now what happens in between is something which obviously has to be investigated. But then if you look at it from this perspective, there is a lot that the state has to answer for. There is a lot that the state has to answer for. First of all, why was not the FIR registered? Secondly, what was the reason for the cremation or the burning in the middle of the night? I believe, at least I've read in the newspapers, that they say that, oh, there was going to be a law and order situation, so therefore we had to, cremate her in the middle of the night. Was there some urgency to cremate her at that time? Couldn't they have waited for a day? After all, a body can be preserved for a day, can be preserved for 2 days. What was the hurry in, cremating her? They could have waited for a day, got the law and order situation under control, if there was a law and order situation, and then maybe done the cremation the next day or the day after. So the whole thing is very, very shady.
Absolutely.
So, but you would agree that it denied the family an opportunity for a second
Oh,
post.
yeah, certainly. Certainly. Yeah.
Absolutely. Right. And in this context, we are seeing this narrative of it being an honor killing, which is kind of shocking considering the history of honor killings in India, the caste dimensions of it. And now there's this narrative being widely spread by many networks that this was some kind of an incident. So would you like to reflect on that?
Okay, you see, this is what I'm saying. That the worst case scenario is that she was beaten up by her family. That is the narrative that is being given now. Even then, the FIR has to be registered. Why was it not registered?
Yes, inexplicable.
It's amazing.
Absolutely.
Yeah.
Right.
And in the context of honor killings, of course, we've also handled a lot of cases of honor killing, but it's normally the other way around. It's when an upper class woman has an affair with a man who's lower to her in the caste hierarchy, then her family turn around and kill her as they perceive it to be, a violation of their honor in the caste hierarchy. Here you have the reverse situation.
Yes.
And so, it defies your imagination as to why a family member would kill his sister. But as Justice Lokur said, it's still a matter to be investigated.
Right. And in this context, I also wanted to ask about a case like this being taken notice of suo motu by the Supreme Court. We've had instances in the past. In 2014, I believe there was a case in West Bengal which was taken, which the Supreme Court took cognizance of. In this case, however, there was an appeal. I mean, a PIL had to be filed before it was taken up. So, could you talk a bit maybe about the grounds on which such cases are taken cognizance of by the Supreme Court?
You see, it depends on a variety of factors. Now, here it seems that the Allahabad High Court had taken suo motu cognizance of the events. That could be, I don't know, that could be one reason why the Supreme Court did not take it up. Allahabad High Court is already looking into it. Why should we, look into it also? That could be one reason. But the way it has panned out, there are rapes that are committed on a daily basis. The courts cannot take suo motu notice of all of them. But the way in which this particular case has panned out, normally I would have thought that somebody would bring it to the notice of the Supreme Court, or if nobody brings it to the notice of the Supreme Court might take suo motu cognizance. But I suppose the only thing that I can think of at the moment is that because Allahabad High Court had taken suo motu cognizance, therefore, the Supreme Court did not deem it appropriate to take notice.
Since the matter is sub judice, I also wouldn't like to say anything more than that. But as one of the people who was representing the 100 letter writers, more than 100 lawyers wrote a letter to the Supreme Court of India. What I would like to emphasize is sometimes certain kind of relief cannot await determination even by a court of law. And one of those examples is witness protection. When critical evidence needs to be preserved, in my opinion, a court of law, and in particular the highest court of the land, needs to step in very, very urgently, at least to preserve the evidence, to make sure that an appropriate court of law deals with it in an appropriate manner. And the concern here that I would like to put on record is that After all, the most critical witness was the mother, who was the first person who saw. She would obviously be a very material witness. And in a situation like this, where you're living in a village which is dominated by the Thakurs, which is the caste to which the people alleged to have raped her belong, there is every possibility of the material witnesses being coerced into making statements that they don't really want to make, or into giving up the case. We've seen cases where even rape victims have been done to death. Forget being coerced. It happened in the Unnao rape case. It could be an accident. It could be just anything. So, as a matter of preserving the rights of all the parties, I think it was right on our part to approach the Supreme Court and say, grant immediate witness protection. And the court has issued notice on the question of witness protection. So I would like to pass the question on to Justice Lokur, because he has been party to the framing of several witness protection programs in the context of crime against women as well.
Yes, I think witness protection is certainly very, very important. But here, when you talk about evidence, this girl was, in a sense, the best evidence. Was she raped or was she not raped? Was her tongue cut or was it not cut? How do we know? Tomorrow somebody might just come up and say, no, actually her tongue was not cut. How do we know? Supposing, just assume for the sake of argument that, the medical report says that she was not raped. Like some ADG has said that, we didn't find any sperm, so there was no rape. But if a proper post-mortem had been conducted, videographed, as the NHRC has said in some cases, that would have been the best evidence. But that, in a sense, that has been destroyed. But the family certainly is very good evidence or very good witnesses to what has happened. And they're not being allowed to meet anybody. I also read in the newspapers that their phones have been taken away. Why should the phones be taken away? I find this whole thing very strange, actually.
Justice Lokur, you would agree that by denial of access to anybody, that would include denial of access to lawyers, to legal assistance, to legal aid, and that denial of access to justice is itself a violation of a fundamental right.
Yeah, that's right. That's right. And you see, look at it from the point of view of the family. They've just lost their daughter who has died, right? They believe she was gang raped. They believe she was very brutally beaten up. They know, as a matter of fact, that she was cremated in the middle of the night. The whole episode, has a huge traumatic or an emotional, reaction on the family. And then next day or 2 days later, you go and say, all right, I'm taking your phones away, or I'm sending the, district commissioner to come and talk to you, or I'm going to send some, very senior person like the Director General of Police to come and talk to you. Are they in that kind of frame of mind? When we talk about sexual offenses against women, the Supreme Court has said it, that you must make sure that the victim and the offender do not have eye contact. Why? The victim probably comes to the court after a month or 2 months or maybe 3 months. One doesn't know. But in spite of that, in spite of a gap of 1 month, take the least 1 month, they say you still should not have eye contact. Here we're talking about 2 days, and may not be with the, with the accused, but with persons who are in authority. Just try and imagine what is going on in their mind, in the mind of the family. And then I think we should be in a position to understand what's actually happening.
Justice Lokur, we also have to imagine what is going on in the minds of the state functionaries to be able to do things like this? Are
Yeah.
they not expected to read judgments of the Supreme Court? Are they not responsible for upholding the rule of law? And so, in the context of what you said, the destruction of the best evidence, I would urge you to let us know, are there no legal remedies such as destruction of evidence by people in authority? And you have written a recent article on framing accountability jurisdiction. Would this not be a classic example of laying our hands on some accountability jurisdiction over here, jurisprudence over here?
Yeah, certainly, certainly. You see, what is happening, it has happened over a period of time, it's also happening now, is that the state gets away with a lot of things. You know, now you look at what happened in Jamia. All right, it's come on national TV, so it's not something that is known to few people. It's on national TV. There was a boy who was being beaten up, and some girls had to come forward to stop that boy being beaten up. Right? What right did the policeman have to beat up that boy with a lathi? There were scenes of policemen breaking the tail lights of some motorcycles. There are scenes of policemen in JNU smashing the CCTV cameras. I think it was JNU or maybe Jamia, I'm not very sure. Smashing the CCTV cameras. I don't know how much a CCTV camera costs, but it must be costing quite a lot. So, can the functionaries of the state, in this case the police, get away with doing things which, if you and I did, we would be in trouble? If I go and break a CCTV camera, I'm going to get a notice for damaging public property and pay so much. But if a policeman does it, perfectly okay. No action taken. If I go and break somebody's, tail light or headlight or something, I'll have to pay for it. If I beat up somebody with a lathi, I'll have to pay for it.
And be prosecuted.
And be prosecuted, yeah. But if the policeman does it, it's okay. And he might, I don't know, he might break somebody's leg or break somebody's arm. And you say, it's okay.
Right. So in this context, it's interesting that you mentioned, of course, Jamia and JNU, because one of the aspects of the Hathras incident is the chief minister's statement after, where he said that the kind of media response, the outrage that has come, the protests that have broken out, all this has been framed around a supposed international conspiracy to destabilize the administration of the state. And the international conspiracy is something the chief minister, the head of the government of Uttar Pradesh, is actually saying that there is this foreign funding and this is happening. And we know over the past few years, especially, that this is not something new. Conspiracy seems to be the key word of the government at every point of time. We saw it in the Delhi riots. We saw it in Bhima Koregaon. We've seen leaders say everywhere there are always some foreign elements who are working with, say, anybody who raises a voice against the government, supposedly to create a conspiracy. So could you both maybe talk a bit about how this conspiracy culture has reached such a situation where even talking about an incident like this may end up being called a conspiracy?
So, Justice Lokur, I'm also seeing this only in the last 3 or 4 or 5 years. Uh, Before this, we have seen rapes, as you point out. It's also nothing new. But I am seeing that now every single uh, incident which concerns the public at large, whether it was Bhima Koregaon or whether it was, and let's not forget, Bhima Koregaon is a fallout of a meeting which was, for which our Justice P.V. Sawant has taken responsibility for being one of the organizers of that meeting. It was perfectly legitimate. It was in broad daylight. It was part of the right to organize, part of 191A rights, etc. And yet we are now being told there was a conspiracy. But similarly, of course, in the Delhi riots, right? A conspiracy, a conspiracy, a conspiracy. And then finally, now in the Hathras case, we are again being told that we are all conspirators. I don't know. Tomorrow, you and I and Justice Lokur might be in a conspiracy to, discuss this whole issue on this website, and we might be conspirators. So, in my opinion, it is not just the conspiracy that I would like to draw attention to, but the conspiracy to do what? Conspiracy to destabilize the government of India, conspiracy to destroy the sovereignty of the country, conspiracy for sedition. Okay. Now this is where I find a problem. It's one thing to tell me that I have been part of a riotous crowd and leave it at that. Yes, I will be prosecuted for rioting. But to go that extra step and to say not only was I part of a riot, but that this purpose of this riot was a conspiracy to destabilize the government of India or the government of a state or the national integrity of the country or the sovereignty of the country. This is what I find problematic. In my opinion, the only reason to do that is to bring in the UAPA Act where bail cannot be granted. This is how I would analyze the situation. Otherwise, I don't see any reason why it can't be called a riot simpliciter.
Yeah. Yeah, you see, if you remember, maybe about 50 years ago, there used to be a lot of talk about a foreign hand, right?
Yes.
So when you talk about an international conspiracy, you're saying the same thing. It's a foreign hand that is involved. Now, how long are we going to keep talking about this foreign hand, or this foreign conspiracy, right? And it seems that the idea is you pitch everything very high. The sovereignty of the country is in danger. The integrity of the country is in danger. So, well, you may not be able to prove that. I don't think anybody has been behaving in a manner that is going to, impact on the sovereignty or integrity of our country. So bring it down a little bit, later on. Put it in the chart sheet, sovereignty, integrity, this, that, and the other. Ultimately, somebody might be held liable for riot. Okay, but anyway, we made our point. So I think I would agree with you, Indira. When you say that things are being pitched too high, foreign hand, foreign conspiracy, so on and so forth, just to bring in UAPA, or maybe just to bring in sedition. Journalists are being arrested for writing articles or going to write an article. Recently, somebody was going to Hathras, and they said, "Oh, yeah, this guy is sedition." I think probably UAPA also in his case. I don't know. So yeah, pitch it high, and the famous the answer to all this is let the law take its own course. But then, if you pervert the law, obviously it's going to take a perverted course.
Precisely.
And the objective has been achieved. You keep that person in jail maybe for 1 month, 2 months, 3 months, 4 months.
Right. And years in the case of some of those accused in the Bhima Koregaon case, definitely. And in this context, I also wanted to, of course, bring up something which the both of you have talked about, written about, that is the issue of protest itself. And we talked about conspiracy in the case of a riot, but today what we also see is that many of the so-called conspirators were just people who organized meetings, who organized protests, like you said, exercise their rights under the Constitution. So what we're seeing is also a climate where any kind of protest automatically becomes, there is a possibility that it could be seen as a criminal act, because that is a precedent that is being set by the government through its narratives, formally and informally, through the various WhatsApp groups, media channels, all of them creating this atmosphere. So could you maybe both talk a bit about also what is happening with the freedom of people to protest right now in the country, given the kind of restrictions the government is placing?
Before I make any comments on that, I would like to pose a question, which I hope Justice Lokur will come in on. Justice Lokur, I find that when the ruling establishment, which lodges FIRs for sedition, they conflate the uh, sovereignty and integrity of India with disaffection for the government. Okay, is there a conflation going on here? I may I may have no affection for a particular government, or I may be very critical of a government. I may have a different point of view, but it doesn't mean that I don't love my country. Okay,
Yeah.
I might be a supreme patriot. Okay, and someone who loves my nation, and maybe because I love my nation so much, that is the reason why I'm raising my voice. That's the reason why I'm protesting. But here what we are seeing is that the our ruling powers seem to equate themselves with the nation. Okay, and if there is any kind of calling out of what they're doing, it is as if we are unpatriotic. The word anti-national is thrown at us all the time. So am I seeing over here a complete abuse of even the plain language of Section 124A, that is sedition, and the law declared by the Supreme Court of India? And is it not time to call this out?
Yeah. Yeah, you're right. If you see the statistics about sedition cases, the numbers are rising, right? The NCRB apparently started keeping the statistics only from 2014 onwards, and every year the numbers are rising. Now, the Supreme Court has said not only in the case of the state of Bihar case, Kedarnath Singh versus state of Bihar, long time back in the 1960s, that there must be incitement to violence or there must be violence. Even fairly recently, uh, when the day Mrs. Indira Gandhi was assassinated, some two people raised some slogans. Supreme Court said that's all right. It had no reaction, it had no impact. Two people raising a slogan, so what? It's not an incitement to violence. It can't be sedition. So that is what the Supreme Court has been saying. But today, you have somebody who acts in a play, as it happened in Bangalore. Oh, you're acting in a play. The play has got some hidden meaning or some scene or something or some dialogue or something. That's sedition. So the child's mother is arrested for sedition. The teacher is arrested for sedition. Some teenager wants to shout a couple of slogans in a crowd, which is definitely not going to, incite violence. She's put behind bars and she is there for about 4 months. Right? You have journalists who've been arrested for sedition. Where is that violence? Or where is that incitement to violence? Which is essential to sedition. It's just not there. Some crackpot somewhere shouts something, you say, oh, sedition. Can't be like that. And surely our country is not so weak, that if a handful of people shout a couple of slogans, oh, India is going to disintegrate it. Our country is not like that,
And we have our fundamental rights guaranteed under the
Yeah,
Constitution.
absolutely.
So, to answer your question about protest, I would like to link it once again to the issue of sedition, because it's an issue which I think the Supreme Court needs to revisit. And
Yes.
it concerns an abuse of the process of law. When you say, if you say you have a right to protest, now you have a right to protest against the policies of any government. Now, I saw this in the judgment of Justice Sudarshan Reddy in the Salvajudam case, where he said, we are each entitled to our own view on what is the best path to development. Okay? We all agree that all of us want development for this country. We want the end of poverty. We want an improvement in the standard of living of ordinary people. But there are different paths to achieve that result. And what Justice Sudarshan Reddy said in the judgment was, we are each entitled to our own interpretation of what is the best path for development, so long as it's a non-violent path. Now, when it came to Priya Pillai, the Delhi High Court, uh, through Justice Shakhtar, said she cannot be stopped from going abroad in order to give evidence before the British Parliament that, in her opinion, coal mining was destroying the Adivasis. So we are entitled to our opinions, and we are entitled to protest in support of our opinions. If we cannot protest in support of our opinions, then our right to protest has no meaning. After all, what's the meaning of the word protest? I'm saying loud and clear, I disagree with you, right? And I want to be heard. I want to be heard loud and clear. Now, there are ways and ways of doing it. One is to go to court and challenge any action, but it's not the only way. We have a right to protest in public spaces. And this is what I think is being compromised by filing cases against us when we protest for so-called sedition,
Yes.
or for rioting or anything else.
Yeah. I would also say that the judgment of the Supreme Court, the Constitution Bench judgment in Kedarnath Singh is pretty clear, right? Now, when a person is charged with sedition because he or she has given a particular opinion or has expressed a particular opinion, I think it's the duty of the trial court where that person is produced to say that I want to know how is this sedition, and because it does not amount to sedition, therefore a police remand is declined or bail is granted. I think the lower judiciary, the trial courts have to be alive to the fact that there is a judgment of the Supreme Court and you have to implement it. That's it. And if the police brings somebody and says, well, this man has committed sedition, all right, on what basis are you saying he's committed sedition? He's committed sedition because he's written an article. So, does that amount to sedition? It doesn't amount to sedition. So, therefore, I decline to, give police remand. Or if he's applied for bail, I grant him bail. If the law laid down by the Supreme Court is followed, then all this would stop. But unfortunately, it's not happening. That's one of the main problems. And so therefore now you have an increase in UAPA. So you say, all right, this person is a terrorist.
By that definition, we would all be terrorists for even discussing these issues. But just a few words, perhaps you could tell us about this growing tendency of abuse of the process of law, of what we understand by the word malicious prosecution, of when a police officer knowingly files a false FIR or a false charge sheet against us. We feel helpless. We feel helpless either as recipients of this FIR or as lawyers defending a person against whom such an FIR. So, can we think of some remedies against abuse of the process of law?
I think one is that if a situation like this arises, the courts have to be tough. They it very well that the police and the courts just don't get along, or the police and lawyers just don't get along. They can't, right? It's not something that is happening today. It's been there for centuries. So the courts should question on what is the material that you have. If you don't have any material, I'm not going to help you, just because you think somebody is a terrorist or just because you think somebody is seditious or whatever. The courts have to be tough. The lawyers, if they're given an opportunity, well, they will be tough. We've had instances in Delhi where, things have been manipulated, but the lawyers said, no, we want to go into it. And it was found by an independent commission, by a sitting judge of the Delhi High Court, that the records had been manipulated by the police. So the legal profession, the lawyers in the fraternity have to be tough. The judges have to be tough. We are not dealing with small things. We are dealing with constitutional rights. We are dealing with the freedom of speech. We are dealing with the freedom of expression. We are dealing with the right to protest peacefully. Right? So if those rights are protected, and they have to be protected by the courts, by the lawyers, and of course by the state, because if somebody files a false charge sheet, the state should also come up and say that, listen, what are you doing? They can't get away with all this. Or at least they should not be allowed to get away with all this.
So it does seem like a very long battle that we have to wage. And in that context, if you could tell us a few things about a very interesting article that you wrote recently in The Wire on building an accountability jurisprudence.
Yeah, we have to. You see now, this the Allahabad High Court had said, when these posters were put up of these 50 people who are supposed to have damaged property, right? The Allahabad High Court said that the hoarding should be removed forthwith. That is the word used, forthwith. The state of UP filed an SLP in the Supreme Court without a stay application. There was no stay application. So the question of the Supreme Court granting a stay against the order of the Allahabad High Court did not arise. But that hoarding was not taken down until there were some rains and a storm and all that, and that storm took down the hoarding. Okay. So here you have a situation where, on the face of it, the order of the Allahabad High Court has been violated. No action taken. They've sent notices to all these people saying that, you pay for it. Okay. Now, one of the items which I read in a newspaper, it was a very good article written by somebody. It said that shoes have also been included, the shoes of some policeman or something. Now, what is the value of those shoes? How do you know? Is it the value, the price at which it was purchased? Or is it the depreciated price? Were the shoes 2 years old? I mean, what's going on? So,
are we tempted to say the law is an ass, or it's too serious a matter to say that, because somebody's life is on the line, somebody's liberty is on the line.
Yeah. And people have been asked to pay a couple of lakhs. Shoes costing 2,000 rupees. I don't know. Maybe they don't cost 2,000 rupees. How do I know? I mean, it can just go on and on and on. But look at it from the reverse side. You have the police breaking somebody's motorcycle lights. You have the police breaking a CCTV camera, which belongs to the state. No action taken. Why? When you talk about equality, you've got to talk about equality in every aspect. You can't say that, equality only in some aspect, not in some other aspects. So this accountability, I think, is important. And it is becoming more and more important. There was some gathering or something in Delhi. The railway station, the metro stations were blocked. They were closed under the orders of the state. Barricades were put up, right, so that people can't go. Now you inconvenience everybody. You inconvenience hundreds of people who are using the metro, thousands of people maybe who are using the metro. And you say, no, 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 it's perfectly okay. Why? Because some people, and every time we are told, handful of people who are protesting, all right. If it's a handful of people who are protesting, 20, 30, 40 people, so you can't control them. So therefore you inconvenience, a couple of thousand commuters. What logic is there in this? I find this whole thing very strange, actually.
I got the impression reading the article that you were suggesting that these are ways and means of curbing protest.
Yeah,
It happens through what looks like an innocuous measure, but the intent of the measure is actually to, block people from gathering or block people from protesting at a particular point of time in different ways. So an administration doesn't even have to announce that they are going to stop a protest. They can just do it by withdrawing transport, public
yes,
transport. That was the impression that I got on reading the article.
yeah. Also, these protesters, they are put into a truck or into a bus or something. They are taken to the Delhi border and they're left over there. How are they going to come back? Nobody thinks about that. So from the Delhi border, they have to start walking back home. If they're able to catch a bus or something, good. If they're not able to catch a bus or a scooter or a taxi or something, walk back home. So these are ways and means of, which are being employed, putting up those barricades. We've got intelligence report that there's going to be, a problem. So we put up barricades. So there's a huge traffic jam. On one particular day, guys were stuck in traffic for 2 hours. Why? Because they said, oh, some intelligence report is there, there's going to be a problem. So ways and means, and every day new ways and means are coming up to ensure that protests don't take place. So you now have protests confined to Jantar Mantar. My understanding is that the capacity over there is maybe about 1,000 or 1,500. Right? What is the use of a protest like that? Supposing a lot of people want to protest. Farmers, for example, they're doing rail roko. Why are they not being arrested? They're stopping trains. So it can't be selective. And if you tell farmers that, listen, you just go to Jantar Mantar, only 1,000 of you. I mean, I don't know.
Lokur, I am fast getting the impression that uh, the judiciary in this country is silent, for want of a better word. And as so far as I know, the only means that are available to citizens at the end of the day is to approach the judiciary for relief in situations of this kind. And if the judiciary goes silent, hear no evil, see no evil, speak nothing, then do we do we have a way of reclaiming the judiciary for ourselves and for the people of this country? I'd like to ask you this final question. How do we reclaim the judiciary and bring it back to its core function of delivering justice?
Yeah. You see, I have expressed a view on more than one occasion that our judiciary should introspect, right? There should be a dialogue. If the judiciary thinks what they're doing is right, perfectly okay. Have a dialogue, have an introspection. If you come to the conclusion that what we are doing is okay, a lot of people are talking a lot of nonsense, fair enough. If you think on introspection and dialogue, with amongst themselves or amongst others, lawyers and so on, that something more needs to be done. Fair enough, do it. But not doing anything, or apparently not doing anything, because I don't know if something is happening or not. But apparently not doing anything is not helping anybody. I very strongly think that it is the time has come. There is a lot of uh, criticism, so to speak, about the judiciary. It may be valid, it may not be valid. I'm not going into that. But as long as it is there, it is time for the judiciary to sit down and introspect. I'm not only talking about the Supreme Court, it could be the High Court. Maybe some strange decisions have come from a particular state, or the district judiciary of a particular state. The High Court judges need to sit down and say, why are we getting these strange orders? It could be any state. But I think that, introspection, trying to find out, are we on the right track? I think that's very, very important.
Very interesting suggestion. I think some kind of a self-audit by the judiciary of its own functioning from the point of view of rule of law, which is, in my opinion, the core function of the judiciary. How do you maintain the rule of law? And that if there could be a judicial audit, even if it is a self-audit, even if, as you say, the judiciary, if they introspect even within themselves, if they could come up with some understanding of where do they stand on the issue of rule of law, that for me is a very interesting suggestion that you're making. And
you see, take sedition, for example. Why is bail being denied to people on the ground of sedition? Now, it is something which I think a lot of people in the legal profession are talking about. Is it not possible for the judges of the High Court or of the Supreme Court or whatever to sit down and say that, listen, why is it happening? And is it right? Should bail be declined? If they come to the conclusion that yes, bail should be declined, fair enough. But if they come to the conclusion that bail should not be declined, and it is being declined, some corrective steps will need to be taken. So yeah, introspection is necessary.
Unfortunately, Justice Lokur, an impression has gained ground in the media and among the public that judges have become executive-minded. What they deliver is what the ruling parties or the governments of the day want them to deliver. This is the sad reality that we are faced with after having devoted our life to the judiciary, you as a judge, me as a practicing lawyer, and it makes me at least hang my head in shame.
Yeah, there is, people have said that the judiciary has been executivized. But then, think about it.
Thank you so much, Justice Madan Lokur, Senior Advocate Indira Jaising, for this conversation, for taking us through some of the problematic aspects we see today, some of the possibilities ahead, and like the both of you said, may there be better days in the future as well. Thank you so much.
Thank you. Thank you.
Thank you, Justice Lokur. Thank you. We'll be in touch with you.
Yeah. That's all we have time for today. Keep watching NewsClick and the Leaflet.